Good afternoon. My name is Ted Liu. I'm an attorney here at Liu, Kelly & Price. I'm here to answer some questions regarding the claim closure process and a workers' compensation claim. When an injured worker reaches the point of being medically stationary, which means your doctor is basically saying that they don't expect you to keep getting better, and in other words, your recovery has finished, that does not automatically mean that you're 100%. It just means that your medical team is saying that they've done everything they can for you and they don't expect you to get any better than you are. At that point in time, through the legal process, the insurance company is supposed to evaluate how much your recovery consists of. Did you recover fully, or did you not fully recover? If that's the case, then there's a certain amount of what we call permanent partial impairments. It's usually a one-time evaluation right at the end of your claim being closed, and there's a legal process for that involved. It does rely upon certain rules within the workers' compensation system, and that can be pretty complicated, and that's where obviously our office can help out, answer some questions about your claim closure. One important thing to keep in mind is that even though you may have it, there's no such thing as called pain and suffering. So if you have an injury and it hasn't recovered fully, there isn't truly an award of money just because things aren't the same as they once were. There's actually a couple different ways your claim can close. One way is if for some reason you're not treating with the doctor as often as you should have, the insurance company can send you a letter saying essentially that they're going to administratively close your claim because you weren't or haven't been treating with your doctor like you're supposed to. But the more common way is that you've reached a point where your doctor says essentially, I can't do anything more for you. This is as good as I can make you. And we evaluate what your impairment is at that point in time. The impairment part itself can be consisting of things such as surgery, loss of range of motion of a part of your leg or arm or shoulder, even a back for that matter. And then in some cases, depending upon if you have permanent restrictions and you didn't recover fully, but your doctor says from here on out you really can't do certain things, and that's their permanent recommendation, there's an evaluation for that as well. In some cases the answer is yes. There is something that we call vocational retraining, which you have to meet certain criteria to be eligible. But if you are eligible, then it is a form of going back to school or some sort of vocational retraining to learn how to do a different job. If because of your injury, you don't recover well enough and you're not able to go back to the job that you held at the time of your injury. There is a limited window to appeal something called the notice of closure. If you receive a notice of closure, the paperwork will tell you that you have 60 days to appeal it. After that 60-day closes, then it's essentially too late. So if you get a notice of closure, call our office, let us know that you have a notice of closure in the mail that you've received, and then we can discuss what the steps are. But there is an appeal process to go through that and appeal the notice of closure that doesn't cost you any money. Generally speaking, once your claim closes, that's not the same as a full rejection or denial of your claim. Instead, you have certain rights that extend past the time of or date of your closure notice. That 5-year window is what we call aggravation rights. So once your claim is closed and you get the paperwork called notice of closure, the paperwork will explain what date your 5-year expiration is, but you have a 5-year shelf life of additional rights. After 5 years, you don't lose all your rights, but you have less rights after the 5-year mark than before the end of that 5-year anniversary of the claim closure.